It's 10:30, so I will go ahead and get started. I want to welcome the Debt Collector Advisory Committee here. Before the commissioner proceeds with opening remarks, I need to go through a few housekeeping items. So this is our first hybrid meeting under the new public meeting requirements. So please bear with us as we work through the new protocols. We are meeting live in our Sacramento office and via Zoom. This meeting is recorded. In the room today is myself, Deputy Commissioner Melinda Lee, and committee members Cindy Yacklin and Desiree Orth. Online, we have committee members Robert Tavalli, Scott Hyman, Sean Welsh, Holly Miller, Angela Reed Becker, and then from DFPI, we have Chloe Hewlett and Emily Gallagher. We will later be having joining us Suzanne Martindale online. I believe she'll be online, and Colleen Monahan will be here in the room. They have an overlapping commitment, so they will be here a little later in our meeting. So now let me turn it over to Commissioner Chloe Hewlett to give us our opening remarks.
Well, good morning, everyone. It is a real pleasure to be here with you today. And first, though, I'd like to take a moment to acknowledge the incredible work that you've all done to help the department stand up our new licensing program. I want to convey my appreciation for the progress you've made so far with approving new applications. Thank you, thank you, thank you. As we all know, our debt collector program is still in its implementation phase. In 2023, we reviewed over 90% of the applications submitted. We also successfully completed the necessary legal challenges to move forward with the background checks, and we established a system to accept annual reports online. Other department-wide activities included a rollout of the new consumer self-service portal, ServiceNow. The new system allows our Consumer Services Office to process complaints more efficiently. It also provides a way to use the data collected to improve the level of service we provide the California consumers. On February 26th, we will be launching a new phone system, which will allow greater access for all licensees and applicants to talk directly to staff. Additionally, DFPI is working hard on various regulation packages. Our legal team will be providing more details on these efforts later in this meeting. We welcome your input on these important topics and rulemaking activities. Thank you for the opportunity to participate in this meeting to learn more about your thoughts, current concerns, and how we can work together in the coming year. And thank you again for your continuing contributions to further the mission of this committee. Your efforts and insights have been invaluable. Now, I will turn the whole program back to Melinda Lee to continue with today's agenda.
Great, thank you, Commissioner. I just want to review the agenda very quickly. I'll do a quick program update. Then we are going to allow 45 minutes for an interactive conversation with the committee and DFPI to discuss our most recent drafts of new regulations. There's 2 of them that are out currently, or One's just finished comment, the other one just went into comment periods. Emily will go over those shortly. And then after that, we will have 20 minutes for the committee members to address any other topics that they would like to. And the last 10 minutes of our meeting will be for public comment. Attendees that are online, we actually don't have any public in our room right now. So all the attendees that are online, you can add comments into the chat at any point. We do save these comments and review them all after the meeting. You also can ask questions. We may or may not have the time and the ability to answer them during the meeting. Okay, so let me start with some of our program updates. We do currently, as of yesterday, we had 1,174 approved applications. We've actually reviewed a lot more applications than that, but we have had some that have gotten withdrawn, abandoned, people have surrendered as things have happened. So, but what we have of actual licensees is we are very near our 1,300 goal that we thought we would have by the end of March. And we still see no reason that we will not reach that. The phone system that the commissioner mentioned, it will take us a little longer to actually go live. We're getting the phone system. It will take us a few weeks for us to learn how to use it and get everything set up. So we will send out a GovDelivery message when it is actually working, and establish when our office hours are, so that you know at what point that you can call us and actually get someone. And outside of office hours, there will be a voicemail, so you will still have the ability to use a voicemail system, and you will get a call back. We are currently in the process of doing our annual reports. So anyone who was licensed as of 12/31/23 should be filing an annual report by March 15th. This is our first attempt at annual reports. It is a learning curve. So it has gone relatively smoothly, but we did have to send out some additional instructions last week. So please take note of what those instructions were. And also, as mentioned, that the legislation passed for us to do our criminal background checks. So those will be processed through NMLS. We are currently getting the system set up and all of our people trained. We expect our go live date to be March 1st. The first group that will be completing their criminal background checks are the MU2 filers associated with the MU1s, which basically means it will not include branch managers. So it will include the whole rest of the group. So we will send out a message the day we go live, but we will not be putting any license items on accounts at that time. So we're going to allow the first 30 days for everyone to kind of look at the system and build up their own expectations of what needs to be done. This will also allow anyone who already has a criminal background check in NMLS that is not expired to give us access to it. And then on April 1st, we will actually put license items on everyone's account who has not already granted us access and who needs to do a criminal background check. By law, everyone has 90 days to complete them. So that will equate to basically they're all going to be due June 30th. It will take us a few weeks to process everything and to switch your account status from approved conditional to approved. But that's what you would expect. So once we have reviewed the criminal background checks, that's what you're going to see in NMLS is you'll get a change of status and your conditional aspect of your license will be dropped. Okay, so that's our kind of quick overview for the what our program is doing right now. And let's get into Emily's presentation. And she's going to go through a few things and I'll just hand it over to her.
Thank you, Melinda. So I just want to make sure that I keep us on track. You said 45 minutes. So that would be 11:25, 26.
We gave you 11:30.
11:30. Okay, great. I just want to make a note of that so that we can try and get through all of this. So I want to start by just pointing out that this rulemaking is the one that we looked at previously as a group. We saw the first draft of the pre-notice, the first pre-notice draft that we went through at another advisory committee meeting. Since then, we have taken a few items, the annual report item out and put that into a different rulemaking, which is on our website, Pro 01-23, and it was published last Friday, February 9th. So that is not pre-notice, that is officially published. And the comment deadline for that is March 27th. So we're not going to be going through comments to that rulemaking in this discussion. That is in the form, the more formal comment period, the published comment period. So please provide written comments by March 27th to that item. What we're going to do here is run through the current draft, which we're calling the second draft of pre-filing or pre-notice rulemaking, which means this is the least formal part of rulemaking. This is an opportunity for you to make your comments, tell us what you think that this means, the consequences it may have for you, for the industry. It's an opportunity for me to ask follow-up questions to make sure that I fully understand your comments. So it was really valuable and useful the last time that we did this, and I'm looking forward to going through it. As you'll see, we've finished the written comment period for this informal draft, for the second draft. So those comments, we posted them publicly to the website. So I'm hoping some of you may have had a chance to look at those. We've gotten really useful comments that way. So I don't know if you did or not, but hopefully you did. So let's dive in. As you can see, so I've got help here from Sergio with the projection, which I really appreciate. The first thing you may have noticed is that for 1850 definitions, we have a lot more definitions than you saw in the first draft. That is not because we drafted or created those definitions. Those are already adopted. They were adopted early within the first year after the DCLA was passed. So we just put them in because when it comes time to file with Office of Administrative Law, they like to see the entire section that we're adding something to. So that's why you see kind of all of these. If you scroll down to the end there, you'll see I. Keep going, thank you. It's going to be the underlined. There we go. See where it says add? Perfect, thanks. Employee. So that's what we had in the first draft. And there were no changes. We made no changes to that section in this draft. So let's just start there. I'm going to go ahead and open it up just to the advisory committee members. My plan is to go section by section. I'll say what we did and then open it up for you to tell me what you think of that. So are there any comments or thoughts on us not changing this? Are there changes you'd like to see? Or do you prefer we didn't change it? Feel free to just speak up because I can't see all of you necessarily. So if you use the hand raise function, I might not be able to call on you. So
I believe there was a comment with regards to the definition for employee that it did not cover 1099 employees.
Okay.
Specifically, the concern was temp agencies or temporary workers who aren't independent contractors or freely independent contractors. They are actually serving an employee purpose. So perhaps we may want to remove on a W-2 form because it is so specific and it doesn't allow for temp workers, which a lot of businesses use.
Okay.
So Kelly, this is Scott, and Emily too, Scott Hyman. I'd echo that, and then also add on to that comment two points. 100% true that businesses use temporary workers from time to time, and should continue to be able to do that. Secondarily, it's at least well established under federal law the doctrine of the de facto employee exception, where a company may be able to not only use one or two temporary workers, but might be able to hire another, I would say another licensed agency to assist it to do the work that the licensee is doing under the name of the licensee. And so they are effectively a de facto employee of that agency, even though they don't work for the agency. And that federal exemption, or that federal doctrine of the de facto employee, should be maintained.
Okay, I appreciate both of those. Scott, when you said another licensee for the de facto employee, did you mean another DCLA licensee? Like they would share with each other? Okay.
Correct. So say I'm ABC licensee debt collection company, and let's say I get a new account, right? That one or two temporary workers is not going to be able to handle, and I can't hire fast enough. I should be able to go to licensee named DEF licensee,
Mm-hmm.
and retain them, and they work under my supervision. There's, again, it's a well-established doctrine in the federal law, to where those people essentially act as de facto employees, even though they're not W-2s.
Okay. Okay, any other comments on this from the advisory committee? So I see we're getting some comments in the chat. So if it's an advisory committee member, if you could definitely speak up your comments rather than write them in the chat, and then we'll leave the chat for public comment, because that can be reviewed at a different time. Okay, so let's move down to the next definition. Oop, not quite so far, sorry. Yeah, engaged in the business. So again, we didn't make any changes to the engaged in the business definition, engaged in the business of debt collection. So are there any thoughts about that from the committee?
I'll chime in.
Sure.
So two questions. One is when, and I think there were comments to this effect in the public comment about particularly first party creditors. If we're talking about subsection A, financial institutions are not engaged in debt collection for profit and gain for gain. Their business is the financing of the product that is being sold, and that's a distinction, I think, that's important between engaging in the process of debt collection for profit or gain. On subsection B, I think the terms regular, frequent, and continuous are terms that are relatively established under federal law. The question though is the term activity, right? And what constitutes debt collection activity? And the things that I would raise are relate to things that I've spoken to before. But for example, things such as is communicate two lawyers communicating with each other. Is that activity within that within that section? So that entities who want to comply with the Debt Collection Licensing Act and be able to determine whether they're in compliance or whether it's necessary, need to be able to, so to speak, count on whether what they're doing is activity that is regular, frequent, or continuous in nature.
Mhm.
So I wanted to just raise that one issue as an example.
Okay. Just give me 1 second to make a note. Okay, any other thoughts on this section?
Oh, sorry. So
Yeah.
Scott, I was just questioning, to add on to your comment there, were you suggesting that additional specific language be added to that section to define what constitutes regular, frequent, or continuous? Like communication, I think you mentioned?
Well, I think the point is, my point is that is that certainly compliance with regulations, it shouldn't be a guessing game. It should be clear to people, to licensees, to know that they're in compliance. And while again, I think that regular, frequent, and continuous is something that can be subject to interpretation. Before you even get that, before you even get there, we need to understand what we're counting, what types of things we're doing that are being counted, so that we know that this particular thing that we're doing isn't a quote unquote activity. So it doesn't count in whether I'm trying to figure out whether I am behaving and acting regularly or frequently or continuously. Did I answer your question?
I think just adding on to what you're saying there, Scott, like a proposed definition or clarification of the word activity in my mind is any movement or any act towards collecting, in furtherance of collecting the debt.
I'm sorry, who was that speaking?
Desiree.
Desiree. Okay, thank you. Sorry. Couldn't quite tell from here.
Yes, we're small.
I would actually also like to chime in on this particular section, not section B, but section A.
Mhm.
Is the intent here for those who solely engage in the debt collection for profit or gain? Is this meant to exempt those who initiate loans? Because I think that additional language would need to be added because it's confusing on my end. I literally can't tell which one this is for. Because as stated before, if you are initiating loans, you are not solely engaging in debt collection for profit or gain. You are actually trying to reestablish the initial contract, which is actually your business.
This is Robert. What about first party where you're working on behalf of a client and just closing out accounts? You're not really attempting to collect as much as you are closing out invoices and reviewing again, in their own system, even just they're outsourcing the service that you contact their customers on their behalf. Is that something that would fall in this too? Or maybe Scott?
I would like a little more clarification on what you're talking about. So these are people who are contacting consumers
they're contacting consumers, but they're only contacting them to close out their invoices. They're not demanding, they're actually allowing for the customer to process their payment back at the client site, just reminding them to clear it out, and then they close out the accounts. They don't even pursue them past a certain point. They just ask, they bring it to their attention, like the insurance is paid, it's follow-up, and they're going to ask them to see if they still have an outstanding invoice, if they want to clear it off at that point, and then it closes the account. It's just something very, very simple. And it's not as a collection agency as much as it is just a follow-up service for a client. I'm not sure how that would fit
So
in.
it's to ask the consumers to make like a final payment.
Yeah.
Okay.
And then close out their accounts, something along those lines. I know that's a broad stroke, but I see different companies that go in and do first party work. It's really not collection. I mean, as much as it is just follow-up work to close out the accounts. They're not asking for, they're not trying to enforce a debt.
So I'd like to either get some clarification or just chime in here. I think I might be misunderstanding you, Robert and Callie. Regarding the origination of the debt, if there's, the way that I'm reading that first part is that if there's any collection happening, not if it's solely the purpose of the business. And to the other point about on the business end, contacting the consumer to say that the account is being closed, would you like to make a payment? To me, that sounds like debt collection. That sounds like you're seeking to collect the remaining amount or not do it. But, from the consumer point of view, that is debt collection.
Okay, so, and again, even if it's first party,
Yes.
okay, that's where I'm asking for. I don't understand the.
Yeah, because there's the debt buyer world, and then you've got the original creditor world. Both business types can collect a debt.
Right, but if it's current debt, it's not delinquent debt.
Exactly, and that was my point, Robert, is that the act of debt collection simply means that we are collecting on delinquent debt.
Yes.
And that's where the debt collectors, debt buyers, et cetera, that are licensed under the act come into play.
That's the clarification I'm looking for, Cindy. Thank you.
Yeah, so maybe that language needs to be added, that we're defining that debt collection pertains to delinquent debt.
Yeah, and again, I think, back in the debt buyer arena, originally, there was a question of what is original debt and what is, purchase debt. If you purchase, you're not the original creditor in a case under debt buying, but they all thought they were years ago. That evolved into what type of debt is it? It's delinquent debt. So what I'm talking about is something where a client asks that we follow up and close out their accounts for them on their system even, and they're basically just asking they're outsourcing that part of a service just to close out the accounts. That's not delinquent debt.
Correct. And I think that actually addresses my comment as well, because my concern was that if you are still under a valid contract, whether that be loan or credit card or whatever financial product, is it really going to be covered here if you could simply make one payment and recapture that account?
Yeah.
That seems like overkill.
That's the clarification. Thank you. That's what I'm looking for, is that clarification. And I think something needs to be written in here and I think Cindy, you addressed it. It's delinquent debt. If it's delinquent debt, then it's collection. I have no problem with that. And that's why I related to when debt buyers originally got started years ago, they were buying delinquent debt, but they considered themselves the original creditor, and that got clarified. You're not the original creditor. You bought a debt, and the meaning of the debt or the status of the debt is what determines what you're attempting to do. That's delinquent debt that you're buying. So you're governed because it's called consumer protection for a reason. So.
And so, Robert, just to add on to that and to possibly respond to Desiree a little bit, that's the distinction, I think, between a debt buyer who would be in the business, who would be in engaging in debt collection for profit or gain. They derive their profit or gain from the profit of collection, versus an original creditor whose business is not deriving their profit from debt collection, but profit or gain from debt collection, but is in the business of financing products, typically, right?
I think so. And again, the issue that contract would be under would be more about closing out accounts and making sure that they're clean, and then there's no further pursuing of the debt even if it went delinquent. That's not the area that first party service would be. It would be more about making the person aware that they still have a balance, closing it out after the call and being done with it. So just as an added service to the client.
Okay,
So
is
Emily,
that,
does that help to add, you
Um,
know, language? I don't know if you need something specific there, like under A, where it says engages in, you know, somewhere in like A, add the word delinquent.
I definitely do understand the comment that the comments that the group is making about wanting this to apply only to some members of the group wanting this to apply only to past due debts. Yes,
I think that the key,
or delinquent debts.
something needs to be in there that it has to be related to the debt collection of delinquent debts
Mhm.
for a profit or gain, because, you know, really, otherwise it could be misconstrued down the road based on who's reading it. And I think that's where it needs to be clarified.
Okay. Any other thoughts there, or we'll move to the next section? I've got all my notes from your comments. Okay, so let's scroll down. It's going to be N. Well, just past N. Yeah, O, right there. Thank you. Law firm. Yeah. So this relates further down to our addition. Oh, you can leave it. I'm sorry. Leave it at O. Thank you. Yes. Perfect. So you can stay there. I just want to say, for this section, the additional definition of law firm, this relates to the addition of a section describing when attorneys and law firms would need a debt collector's license. So just for purposes of this conversation right now, I'd like to stick to the definition of law firm, and we can discuss the broader issue of when and if we should require attorneys to be licensed for further down when we discuss the actual section that requires it, because that has more detail in it and it'll be easier to discuss when we have that in front of us. So for now, are there any thoughts about just the definition of law firm?
Yeah, just one thought that we may want to go back and look at a case back in the early 90s that finally settled. There was a case related to, I believe it was Haight Landau, that addressed what a law firm is versus a sole proprietor. You know, and a law firm that's practicing collection generally had staff that's asking people to pay, has a staff of attorneys that are there, and they're actually acting as a collection agency, as opposed to a sole proprietorship who may process a legal action, which is already governed under the law. A couple of years ago, a few years ago back, one lobbyist tried to bring that back, and we had to remind them. They were trying to say that law firms they were inadvertently cast into this. And I came back and I said, no, actually, law firms specifically were the reason the law was written, that said law firms acting as collection agencies are collection agencies, whereas an individual lawyer practicing law or processing a legal action on behalf of a debt collector was doing his job under the legal guidelines. So that may be a case that we want to look at, because we actually got the lobbyist to drop that bill because he realized why the distinction was made between law firms and a lawyer, an individual law firm that just does his own practice. He may have one assistant processing the legal documents, as opposed to a staff of people making phone calls. So I don't know if this is exactly pertinent to that, but I do remember we've had a few issues over the years, going back to 1991 into 2000 and say 15 or 12 or somewhere around there, where this has come up a few times. So
Okay,
I'd like to just add a counterpoint to that. I've been in many cases where it's been a single attorney, working under himself, who is collecting a debt on behalf of their client, but they have been established as debt collector because it's regularly what they're engaged in.
yeah, and I think that can apply. I just think that the key issue is what is the actual activity. I mean, if he's got somebody making phone calls, I don't think most attorneys are going to sit there and make phone calls unless it's on an individual case by case scenario where they're collecting, and most of that's on commercial debt, but where it's coming on to consumers, I could see where that type of application might apply. And I think I'd leave that up to the Bureau a little bit to decide what is the act of collecting a debt, and if it's a delinquent debt. But again, keeping in mind and respect for the law profession, they're licensed under the
Robert?
bar. Go ahead.
I'm gonna kind of like cut you off for a second,
Okay.
sorry.
Go ahead.
To Emily's point, the actual discussion on the lawyers, we're gonna get to that,
Okay.
that activity later. So right now, to refocus on what is a law firm, do we have any comments based on that would mean it's a law partnership, a professional law corporation, a lawyer acting as a sole proprietor, or an association authorized to practice law? Are we okay with that part of it? And then we'll get to the actual activities that lawyers are performing in, because that part is in a different section.
Makes sense to me.
okay. Okay, so let's scroll on down to 1850.1, scope of licensing. There you go, thanks. Okay, just scroll on my separate notes document. Okay, so we did make a few changes. I know we discussed this quite a bit up when we were talking about the definition of employee, but here you can see we made a few changes. We added just for clarity, where we're exempting employees of debt collectors, we're also, from needing a license, we're also exempting employees of entities that are exempted already by the law. So, financial institutions, CFL licensees, et cetera, their employees, their exemption also applies to their employees. And then at the end, we added employees of subsidiaries and employees of parent companies of a licensed debt collector are not required to be licensed while working on a temporary basis for the licensed debt collector. So that gets a little bit to what we talked about before. It may not go quite as far as we talked about above when we were talking about changing the definition of employee, but does anybody have thoughts about this new exemption for subsidiaries and parent employees of subsidiaries and parent companies of licensees being exempted when they're working temporarily for the debt collector?
Emily, this is Scott. There's just some comment in the comments about this is a great start and appreciated, but should also include affiliates.
Okay.
And that's defined in section A of 1850.
Okay. Any other thoughts? Okay. I guess we covered it all up in the definition of employee.
I actually, Scott, can you, when you're using the term affiliate, we have the term defined and it's pretty loosely defined. So what are you thinking when you say affiliate?
I was pulling from this 1850A, the definition that's in
Our
the
definition.
itself.
Okay.
Okay, anyone else? All right, time is really flying. We've got 20 more minutes. And that includes that does not include the kind of open advisory committee period, correct, Melinda? Like comments for that. Okay, so if we were to bleed into their space, that would be up to them. Okay.
That would be up to them.
Okay. Okay, so if we scroll down to B, thank you. Perfect. You can stop. We did not make any changes to this either. The licensing exemption applies to the listed entities and their employees. So that's just so this narrows this is the same as we had it before. It's the exemption it's clarifying the scope of the exemptions that exist currently in the text of the DCLA statute. And it says, as you can read, that it applies to their employees, and it does not apply to parent entities, subsidiaries, or to affiliates. So thoughts on us not making any changes to that section, keeping that definition the way it is, or sorry, that the scope the way it is there? Okay. I'm guessing there must be a section you really want to talk about further down. Okay, so we're going to scroll to C, original creditors, and let's scroll just up a little bit more so we can get more of original. Perfect. Yeah, just so we have a little more of original creditors in. So small changes to C. Original creditor, we've added a creditor, including a provider of non-financial services, seeking in its own name repayment of consumer debt arising from a consumer credit transaction between itself, the original creditor, in its own name, and a consumer is not engaged in the business of debt collection for purposes of DCLA licensure. Any thoughts about either the changes that we made to that section or additional changes you think we should make? Okay. Or yeah. Okay, so you've got 1 up, great. Let me scroll on my notes to 1 and 2. Okay, 1 second. Okay, so we incorporated a fair amount of comments to the definition, or to 1, 2, and 3 based on our meeting last time, and also on the written comments that we received. So we've clarified in 1, 2, and 3 that these calculations are of the annual revenue generated from consumer credit transactions with California consumers. So we clarified that it's specific to California consumer revenue. And we changed previous 12 months to calendar year. There were comments before about how frequently people would need to be making these calculations to figure out their licensure if it was on a monthly basis. So we changed it to calendar year. And then we also included, because this first one covers collection fees, late fees, or any other charges, we clarified that this does not include accrued interest, which was part of the original transaction and would accrue regardless of whether the consumer has met the obligations under the contract. So does everyone understand that? And do you have any comments about the changes that we made there? Okay.
Let me just
Similar.
make sure that
Yeah,
Emily, I
please.
just want to make sure that I understand this section. So you have an entity, an original creditor that this year does not qualify under these calculations for licensure, right?
Mhm.
And each year they have to redo these calculations, but let's say because of other extrinsic economic factors, they do fit into one of these categories because delinquencies are high. Is this, suffice to say, meaning that in those particular years where they have a bad year and they have more delinquencies, they then would have to apply for licensure?
So this does not provide any kind, this is on an annual basis. So there's nothing that I'm reading in this section that would take into account whether in a whether in previous years or whether they expect in the future to still generate that much revenue from fees, collection fees, late fees, excluding interest.
I mean, I'm just curious how the intent behind it with the calculations and how that would be monitored by the department and or the creditors for the purposes of being licensed under the DCLA, because delinquencies are going through the roof right now. And I don't know if that trend is going to stop in the immediate future. So I don't know if the other committee members are, reading into this as I am. I'm just questioning the calculations. And what does that mean for that creditor? Would they have to apply for licensure as drafted?
Yeah, I mean, from what I'm seeing on this drafting, I hear what you're saying, and it looks to me also like they would need to be licensed, but because this is an annual calculation. So if that is what the text is saying, I'm interested in your thoughts on what that, whether that's a good idea, changes you think we could make, if you think it's a concern. Or if you think that's appropriate.
That would be a concern, simply because you can't predict, say you've got a small business that all of a sudden takes a large hit on a receivable. They technically would need to be licensed if their calculation on percentages, and I guess maybe that's the inherent risk of, listing exact percentages that are tied to licensure or non-licensure or exemptions for an original creditor.
Yeah, so alternatives would be licensing all original creditors, licensing no original creditors, or we create a threshold to say they have to be licensed when a certain amount of their business seems to be coming from collecting on debt.
Delinquent debt.
Well, I mean, generally speaking, if you have a creditor, I mean, that's the nature of the business that we do in, debt buying and contingency collections, is that we take over as the licensee on behalf of the creditor so that they do not, we bear the burden of that license and not the creditor, because that is what we do for a living. That's what, we're obligated to know these regs better than anybody else because we live in the space. So I don't think the intent is for the original creditors to be licensed.
And I'll add that the original creditor really is looking at the cost of money and not, if they're collecting a debt and they collect interest or finance charges or late fees, it's all one thing under California. It's a governed thing, but are we talking about money they collect because the account is delinquent, or are we talking about what
Yes.
they charge? Because charging something doesn't mean you're going to collect it. I want to make, or am I getting that right? Because if they're collecting on a percentage of their debt, not turning it over to, say, a collection agency, but they're accruing a late charge or what have you, to me, that's just the cost of them holding and not turning an account over to collection. If they sue it, they go after the interest and service charges or whatever. But what are we talking about here? It seems to me that original creditors should be exempt from anything with regard to collecting on behalf of their own debt.
Okay, so I'll answer, or I'll point you to some language and see if that answers it. So the under sub 1 here, an original creditor would need licensure if 5% or more of its annual California revenue. So that would be not just what it's charged, but what it's collected, because it's its revenue. So it constitutes collection fees, late fees. So not interest, unless maybe there was interest that wouldn't accrue unless it was overdue. So maybe like a bump in interest rate if it's overdue or something. But so if a California creditor is generating 5% or more of its revenue from its late fees and collection fees that it's collected, that's when they would be required to be licensed under this. And So I'm just clarifying that because I really want to know what you all think of that. If you think that's, Cindy, if you still think that's too low of a percentage, or Robert, if you think
Under-
they just shouldn't be exempted or they just shouldn't be required at all to be licensed.
Go ahead, Cindy.
Yeah, I think one, you're talking specifically about collection fees, late fees, et cetera, as part of their revenue. I would think that the more problematic one may be 3.
Okay. Sub 3, the other
5% or more gross
section
amount.
3, okay.
Because it's one or more of the following criteria.
Mm-hmm.
So the easy calculation is if a company does $1
I
million
see.
a year in business, and then they look at what they've collected in delinquent charges and in those costs, and that adds up to 5% or more, they would be required to license. But I have a hard time with that, and I'm not speaking as an original creditor, but well, I'm speaking for them maybe, but I would think that there's a cost of them, they haven't pursued the debt maybe as well as they should have. Maybe they should have turned it over to collection. Maybe they choose to use an attorney to collect it, but they're not trying to make money off of that interest. I want to make it clear. They're losing money by the party not paying on time. And so therefore, that calculation of fee is really to recoup some of their cost of operation and attempting to ask the party to pay the bill. And so I would hope that, frankly, even at a 10% simple interest rate that a client might charge on a consumer debt, that they're not adding up to, it doesn't add up to 5% of their gross revenue. But I just can't see how the original creditor should be implicated here. It seems to me they're trying to conduct business, and there's a cost of doing business, and the cost of money is what they're trying to recuperate. They're not making money on it, on the interest. They're losing money by the account going delinquent and the diminishing returns.
Yeah, I mean, I'm just speaking to 3, thinking about the small businesses that are going to be out there just because they have a delinquency problem within a given year should not, enable them to have to be licensed by the state under this act.
And one more logic is if creditors are not allowed, or they're steered away from accruing an interest, they're going to be more likely just to raise the cost of operation by raising the prices of their goods and services.
I'm just gonna interject here. I think that there's 2 different things happening. I think that Robert's, correct me if I'm wrong, but I think you're saying that original creditors should not be licensed. And I think what you're saying, Cindy, is a clarification as to point 3.
Yes.
Am I characterizing that correctly?
Yeah.
Okay, thank you. Just to Robert's point, I want to make it known that more than half of the debt collection lawsuits that we deal with for our clients are original creditors.
Okay.
There is debt collection activity happening on original credit. Additionally, the state RFDCPA encompasses original creditors for a reason.
Sure.
It's not necessarily about the revenue or the profits that
Right.
that business is making, it's the activity itself.
No, I appreciate that, because the Rosenthal Act, I've convinced it's an ongoing education for me to give my clients that they're governed under California law as an original creditor already. And certainly they can be sued under that because they violated a law. My question is, do they have to have a license to be sued? To me, they should be sued if they're violating any law. We get clients who we have to educate on usury and the understanding that finance charge is no different than interest. And nobody charges interest. Interest accrues on a delinquent debt. And but in this case, you're talking about original creditors being sued versus original creditors having to be licensed. I think that's I have no problem with going after a business for violating the law.
Can I ask a practical question about the way this section would work? If these regulations are enacted as proposed, and a creditor looks at its portfolio and decides that it doesn't meet any of the criteria or 1, 2, and 3, so that it either surrenders its application or decides that one's not required. Then at the end of the calendar year, they look back at an audit of their portfolio and they decide, my goodness, we've triggered the law. Now we have to apply. But if they figure that out on December 31st, they're not going to be able to apply and get the law on January 1st, right?
Hmm.
So will there be some application grace period for those whose portfolio deteriorates to in a way that would make them qualify under this statute to apply for a license?
Okay, I have a couple of questions for the group. I really appreciate this discussion. The first is if I understand the suggestion to eliminate licensure for original creditors. I understand the reasons and the suggestion that we should not do that. If we maintained this section, these three sections, a section requiring licensure of original creditors, would changing these thresholds address some of these concerns? For instance, Cindy, you raised the issue for number 3, because it's 1, 2, or 3. We haven't really talked about number 2, but it's 10% or more of the inventory repossessed. So would changing the threshold, say, for instance, and I'm not endorsing this view, I'm just suggesting it. So if we eliminated number 3 and raised the threshold on number 1 to 25%, let's say, I'm completely making that number up. We could raise it to anything. If we did that, would that potentially reduce the chances of this kind of back and forth that you're talking about, Scott? Okay, well, this year it was really low. If somebody has 25%, is that going to be something that's going to happen less frequently, or is it going to be more of a business model situation if they've got 25%? Versus something like you were saying, Cindy, where, well, maybe one year they get this because they had a bad year. If it's a higher percentage, is it more likely that it's something, that's more reflective of a true revenue stream for their business than just an off year? Does that make sense?
I'm sorry if Cindy was going to chime in. I think that's first of all, this is a great move forward. I want to be clear, and I think that your suggestion that higher limitations eliminate the possibility of accidents and one-off bad years, and are more targeted towards the business model. I think that's a great way of looking at it.
This is Robert. Oh, go ahead, Cindy.
I just still, again, the licensure of original creditors, I mean, the entire act is, for the purposes of those who engage in the business of debt collection. And this section would assume that a first-party creditor is going to engage in the business of debt collection just because they have a receivable problem. And I think that is the, umbrella, large kind of concept that I would take issue with this section.
I'll add, a client that, or original creditor that has 25% of its revenue derived from fees is probably more predatory as opposed to somebody with a lower amount just because they had a higher delinquency. The other thing is that a company with 25% of its income derived from late fees and so on and so forth is probably somebody who's ready to go out of business themselves because they've got a serious problem. So.
And I do want to just say again,
Hey.
that's just a number I threw out there for example. It's not like something,
5% is way too
just for
low.
conversation.
Yeah, I would think 5% is way too low, though. It might be 10 or 15 or 20, whatever you come up with, but it's something that can distinguish very clearly. I'd be in favor of eliminating original creditors because you already have a means to go after predatory folks that are deriving their income on victims of consumer victims. I helped write the identity theft bill in California, and some of the stuff that goes on there, I just totally admonish as original creditors. So
I'll make an observation here, Emily. I think that the common thread with the issue that I see is the calendar year. Maybe that's too short of a term for a look back, because as Cindy's saying, if somebody has a really bad year, that's not really representative of their business. And then just, counterpoint again, Robert, the RFDCPA also applies to third-party debt collectors, but this, that doesn't mean that they're not exempt from licensure. So I'm not sure that that's
That helps.
the way to look at it.
Also, to Scott's point, putting it into play, if a original creditor hits whatever points are decided, 1, 2, 3, or a revision of those, how long does the original creditor have to obtain a license? Can they continue to do business? I think all those pieces probably should be laid
Mhm.
out, so it's understandable what time frame this is identified to when they should actually get their license.
Okay,
Yeah, and that was going to be my comment as well. I think the comment that businesses should be given a certain amount of time to apply is a very necessary one, because you may not even realize that you've hit that threshold until you have an annual audit, which comes months later.
You're not attempting to have those fees if you're trying to get people to pay on time. So recognizing you have a problem.
okay. I really appreciate this. This is a lot more discussion than we had on original creditors in the last meeting. So I'm really happy to be getting some feedback on these. So I'm gonna move on. Oh yeah, so we've hit 11:30. I'm sorry, Melinda. I tried my best.
That's okay. So that's really up to the committee. Did you want to move on? Because we were allowing you guys 20 minutes to have a different conversation. If you would like to just continue with this, raise your hand and we'll go with what the committee wants to do.
Well, I'm open. I think you're being very productive. So for me, it's helpful what you're doing. So I'd be supportive of that.
I would like to continue.
Okay,
To continue as well.
Okay,
Continue,
then we
please.
will continue on, Emily.
okay, thank you. I really appreciate that, everybody. Okay, so I'm gonna move on from original creditors, but I am just gonna hit real quick the only subsection we didn't talk about, which is number 2. Is this, are we not talking about number 2 because it's fine, because you don't have any idea what businesses this would even apply to, because I want to know if there are any thoughts on sub 2 here.
I think my only concern is for very small businesses, 10% is a low threshold. That would be my only concern with number 2.
Okay,
And I'll just add that other counterpoint that small businesses are often the most egregious debt collectors. So just consider that.
I would kind of not necessarily agree totally with that, but I understand they may be even less knowledgeable on how to avoid. A lot of the questions I get from creditors are more along the lines of their naivety or their ignorance and how they perceive things, and I don't know, maybe more clarification on 2 and what it really means. I'm not sure how it would
Because
apply.
I'm not sure it's the intent to not license small businesses that do debt collection.
Right.
sorry, Desiree, will you say that one more time?
Yeah, I'm saying that I don't think it's the purpose is not to exempt small businesses that do debt collection. It's debt collection as an activity as a whole, regardless of the size of the business.
Correct.
Okay. Thank you. Is it all right if we move down to the next section, everybody? Okay. Okay, so D, yeah, sorry, you can't see the whole thing, but that's okay. We'll leave it here for now. So this section, as you can see, discusses an exemption for servicing debt. We changed a little bit. It previously said a person solely servicing debts not in default, and we used default language throughout. We received set comments to that, and changed this to no longer use the language of default, but instead to precisely say 90 days past due and have not been charged off. And then we go on to define charged off. So a person solely servicing debts on behalf of an original creditor, as described in C, that are less than 90 days past due and have not been charged off, is not engaged in the business of debt collection for purposes of licensure under the DCLA. And then we define 90 days past due, and we define charged off. So does everyone how do you understand this section? And do you have thoughts either about the changes we made or more generally about the section and whether we should maintain it?
Can I
I think
ask?
this is a solid addition.
Sorry, Callie, did you have a question?
Yeah, can I ask where the 90 days came from? Like, why is that significant as compared to 120 days or just simply not charged off?
So I think rather than try to explain our rationale for 90 versus 120 versus 60 or 45, it's more it would be useful to me to hear what number you all think is appropriate here for this kind of an exemption, and your reasons for that. And
Well,
then
I would just think that it would be easier to say that has not been charged off because each business is going to establish the charged off date. Something put in the contract.
There are certain requirements under banking that requires 90 days as opposed to other entities that it's a matter of accounting principle. Charged off is one thing. And, like healthcare hospitals have, certain requirements today that they didn't have, 5 years ago, as far as holding on to accounts longer and not charging them off to a collection agency. So yeah, there are some variations there that need to probably be looked at. I think the word charged off is typically at 90 days for banking, but not for most industries.
Yeah, correct.
okay. So the suggestion is maybe remove the 90 days and exempt servicers of debt that have not been charged off, period.
That would be my recommendation.
Servicers who are working on behalf of an original creditor versus
Well, either the original creditor or the servicer, yeah.
Emily, are we defining charged off?
we do. And in the last
That's default.
sentence, yeah, could you scroll down to the next? There we
Yeah,
go.
I
Yeah,
did
there's
not
our
see that.
definition of
Thank you.
charged off. Yeah.
See, that's an accounting issue.
Yeah, so that's our definition of charged off. Does anybody else have other thoughts on this exemption?
I think that complies with the law better, so.
So then we would be saying that it is only debt collection if you've taken it off your books, not if it's severely past due in any way.
That's a clean way for most creditors to operate and an easier way for collection agencies to explain to creditors what, a clean process. We get clients that ask us, should we charge off our debts when we turn them accounts over to collection? Or do we charge them off or do we wait till the year end and charge them off? And we say that's something you need to go talk to your accountants about, but there's different methodologies. And if a creditor, original creditor, is writing off a debt, they're deeming it uncollectible typically. So, and then we recover percentages of that bad debt. So same would apply to the original creditor. They're not anticipating the recovery of that debt typically when it's being charged off.
So under Reg E, unsecured debt is required to be charged off within 180 days, 120 days for secured debt. Is the intention of this paragraph to exempt debt collection that is not in charge-off status?
So this, as written, it is less than 90 days past due and has not been charged off. So yes, this section, as I read it, would exempt servicers of debts who are working for an original creditor if the debts have not been charged off and are less than 90 days past due.
And
So
just
it would exempt, it would exempt. It's a significant exemption, I would say.
And just to just kind of explain my thought process, because there are so many days or so many different ways in which charge-off policies apply, and there's so many different days. My only concern is, did we mean this to apply to accounts that can be brought back current? Because it feels like it wasn't meant for that. So if this was meant to apply to accounts that can be paid and brought back current, then maybe you do want it at 90 days. But if it's meant for accounts that are destined for charge off, 90 days is not the standard across industries.
Plus, I think it adds a level of confusion rather than standing with Reg E and just looking at the definition of a charged off account.
So I have another question unrelated to charge off once we finish that charge off discussion.
Okay. Is that, I think, what's your question?
Sure. So it has to do with, and again, this is a great move towards the retaining the servicer exemption. But when we just finished talking about the creditor, the way that creditor definition interacts with the servicer exemption is and can be confusing. In many finance transactions, the contract is between the customer and the seller, right? That contract is immediately assigned to a finance company, who is, for all intents and purposes, the creditor, although arguably not the original creditor, because the contract immediately assigned what was between between the buyer and the seller. If you read this, they would not be servicing on behalf of an original creditor, especially if if that finance company securitized out that or sold that debt but retained the servicing. They wouldn't be servicing as an original creditor, even though outwardly looking to the consumer, they are the original creditor. And so if they were truly the original creditor, they would be exempt under the definition of creditor. But when they receive the debt as an assignee and then securitize it but retain the servicing, they're not servicing on behalf of an original creditor, so they get brought back in under the licensing scheme. It's a long way of saying that whether it's in the definition of original creditor or it's in the servicing exemption here under subsection D, assignees of consumer credit transactions should be treated as original creditors, so long as the assignment itself was not solely to facilitate debt collection. In other words, they're effectively functioning as the original creditor.
Okay, so we have just about 6 more minutes before we have to switch and do public comment. Is that right, Melinda?
Yes.
Okay, so I'm just gonna close this section out with, I think we had a question from you, Desiree. I didn't know if you had another comment on this or if anyone else had maybe like a final comment on just the general idea of exempting servicers of debts that are not in default or are not past due, not charged off. Yeah,
No, thank you, Emily.
Yeah, okay. And then as we only have 6 minutes, we've got just a few other changes to smaller changes, but then the main addition we have is to the attorney exemptions, or sorry, the attorney licensure section. And I'm thinking we should skip to that because it's bigger and we had a little bit of a discussion on it earlier. So is everybody okay with us moving to that unless there is a different section you would rather talk about? Oh, sorry. We also have the section regarding records retention, which we made a few changes to in response to comments. So what's the group's thoughts on how do you want to spend your last 5 minutes in these regs? Because I don't think we can cover both of those sections. Attorneys or records retention?
Is there a way to accommodate having you create the dialogue on both and then having comments later on it, just so it gets covered? In other words, for efficiency?
Like I run through them?
Yeah.
Both?
Yeah, because I think the key is getting everybody to hear what's in there and
Okay.
the API's approach, and then we can possibly give you more comments later,
That's a thought.
whatever's more efficient for you.
My
Okay.
preference would be on the attorney. However, I do have one question that I'll just throw out there regarding the employee, and I'm just on the record retention as it pertains to employees. If the employee is of the debt collection, if the licensee is not licensed themselves, I'm curious why the information needs to be retained with regards to the personal employee records themselves, rather than the company's policies and procedures regarding, like, say, training or something of the sort. So that was my only, primary question that I had on employees. Why is the department looking for the licensees to retain those specific employee records that are personal to the business, to the employee-employer relationship?
Okay, let me just find that section.
And again, I'd rather focus on the attorney. I think that's the bigger
Okay,
issue.
all right. I hear
just
your
took that
comment
one
and I'll
away.
make a note. I'll make a note of your
Okay.
comment.
Thanks.
And then let's go to attorneys. So scroll down, it would be, yeah, here, actually stop for 1 second, head back up a little bit. Okay, stop. Okay, up a tiny bit more, sorry. Yeah, to the next page, I guess. Yeah. Okay, here we go. Yeah, this is where it starts. So, and then I have to find it on my notes. So we've added a section answering the question of how and under what circumstances an attorney would be licensed. So we have a person is, sorry, there it is. Okay. An attorney or law firm engaged in the business of debt collection must hold a debt collector license under this division. And then the subsections here explain for purposes of determining whether an attorney or law firm is engaged in the business of debt collection, the following activities under 1 do not constitute debt collection. And then we delineate them, representing a creditor in an action initiated by a debtor plaintiff, would not be debt collection, an attempt by an attorney or law firm to collect legal fees or costs from its current or former client. So I would think of that as kind of an attorney being an original creditor themselves. They would not need to get a license for that. And then C, the provision of legal advice regarding debt collection that does not involve communication with any debtor would not be debt collection. And then one more section I want to highlight on this. So the revocation or suspension of an attorney debt collector's license shall not operate to prohibit the attorney from practicing law, including their legal debt collection practice before any court in the state of California. So let's just open it up generally to this, and we can talk about whichever section in the attorney licensure the group wants.
So under 2, does that mean that the attorney who acts on behalf of a collection agency who sues on behalf of the debtor, the creditor, meaning the collection agency, does not have to have a license or does have to have a license if they're suing on behalf of, let's say, my company, they're my attorney, I'm the one suing, they're representing me to sue a consumer. Does that require them to have a license?
It wouldn't exempt, I don't think that number 2, a debt collection license does not, you mean? Oh, B. You mean the exemption? I just want to make sure I
See
see
what I'm
what
trying
we're
to
looking at.
clarify.
The representation of a creditor. So I don't see an exemption here that would apply to that situation.
So they would have to be licensed if they're suing on behalf of a collection agency, a consumer, they would have to be a licensed agency themselves.
Sorry, if they're suing on behalf of a collector.
Yes, on behalf of a collector to collect the
Mhm.
debt, the
Mhm.
collector is the one collecting the debt and directing them on what they need to do.
Mhm.
They need to sue the party, they need to represent the agency to sue the party. And let's say they want to do a writ or a bank levy or what have you,
Mhm.
they're enforcing the law under the governance of being a lawyer. Are they required to be a licensed agency if they're acting in that behalf under this current definition?
So if they're engaged in the business of debt collection, if they qualify under the, yeah, I don't see an exemption for them here in that situation.
In all past years, it's been brought up that attorneys practicing law are not attempting to collect a debt.
Mhm.
Yet under the licensing act, it appears to be that they now are collecting a debt if they act on behalf of a collection agency to file a writ or place a lien on a property or do whatever.
I see. So you're referring specifically to their activity before a court.
Yes.
Okay.
So I'm not sure where that applies in here or not, but it would seem they should be exempt and they shouldn't have to get a license if they're already a licensed attorney to practice law in the state of California. That's really where I'm trying to go with it.
Okay. Yeah, I appreciate that.
So I'll add, I've been practicing for over a decade now, and I've seen a lot of collection activity from attorneys
Sure.
in the state, many of whom I've sued personally because of their collection activities. I think, which paragraph are you referring to exactly, Robert?
Well, I'm not really specifically addressing a particular paragraph, but I think perhaps we get back into the definition of a law firm who has people calling on behalf of, well, literally on behalf of creditors, and then it, let's say the lawyer sues it, that's fine, but that lawyer, when he's practicing collections by having a staff of people calling, definitely is acting as a collection agency in my mind. But where they're representing a collection agency and the collection agency is doing the collection work, it doesn't appear that it should be a licensed activity. It should be, they're already licensed as a law firm. I mean, not a law firm, as a lawyer acting on behalf of the collection agency. So I'm trying to get clarification. I'm not sure if it's in here or not, to be honest with you. So perhaps somebody can clarify that for me.
I'm sorry, is that the commissioner with her hand up?
Yes.
Please speak, Commissioner.
Having been director of moral character for the State Bar of California in the past, I do believe you brought up an excellent point. And I think we need to take that issue offline because that does require some further research and consultation with the State Bar.
I would agree with you, Commissioner.
But you have brought up an excellent point.
And I've been doing this for 45 years and I've seen these cases go back and forth. Like I mentioned earlier, the Haight and Landau, where they staff an office full of people making phone calls. That's a collection agency. It's a duck. It quacks like a duck. It is a duck, as opposed to a single lawyer practicing on behalf of a collection agency. And I think there may be some legal issues there that are already covered under the bar and the state licensing act under being a
Okay, I appreciate the
I'm gonna
comment.
have
I
to
do want to say
cut this
Desiree
off.
was in the middle of a comment.
sorry.
And I want to make sure she finishes it.
We need to go to our public comment period now. So if I could ask my IT people, if there's anyone online that wants to make a public comment. And if you could put up, I think they have to raise their hand, correct?
Yes. There's nobody so far. Wait, Harvey Moore.
I'm going to allow you to talk to ask the question.
Thank you. My name is
Yes.
Harvey Moore. I am the president of the California Creditors Bar Association. And I also have a collection law firm in Santa Ana, California. My concern about the language that you have regarding attorneys is that, yes, the act of filing a lawsuit is not a communication with the consumer, but the minute the consumer communicates with us, or we intend to communicate with the consumer, we're required to follow the rules and regulations of the FDCPA and of the California Rosenthal Act, which means we have to send the initial demand letter. We have to give them an opportunity to dispute the debt. We have to respond to a dispute with a validation response. Everything we do is subject to the state and federal law. And my concern is that you say in these regs that if we don't have a license, we can still practice law in court. But to file that collection action and communicate with the consumer, we have to satisfy our obligations under state and federal law. There are provisions in the Business and Professions Code that define additional obligations that we have as attorneys doing debt collection. So I am very concerned that the DFPI is seeking to regulate the practice of law when the operative law that created the DFPI licensing requirements said that you can't regulate entities that are regulated by other state entities. And the State Bar of California is a state entity for purpose of regulation. So how do we deal with this conundrum?
I don't think we have an actual answer to that, to your question. However, we will definitely take your comment into account, and we will, as the commissioner said, have further conversations about the exemptions that are surrounding the sections that Emily is currently reading.
Can I ask a question?
Yes.
Can I ask you a question? When you say the provision in law saying if you're licensed by another entity, you're not subject to oversight, are you talking about referring to the provision in the California Consumer Financial Protection Law?
I am referring to the provision that created the DFPI that specifically says that the DFPI cannot regulate entities that are regulated by other state licensing entities. And the State Bar of, and we have put this in our written comments. Every time there's a request for comment, we've been very consistent in our position that the State Bar of California regulates the practice of law, and therefore the DFPI can license attorneys, but based on the operative language that created the DFPI's right to regulate, it cannot regulate an entity that's regulated by another state entity.
Okay, thank you.
Do we have anyone else that has their hand raised?
I see no other hands raised.
Okay. Well, we are at time, so we are exactly at noon right now. So I would like to thank all the committee for joining us and all of the DFPI team for supporting this effort. And we do not have a meeting scheduled, but we do anticipate that, yes, we will definitely have another meeting this year. We will probably look once again in relation to our reg packages, since they do provoke such a active conversation that we will look again at what our reg package schedules are so we can further discuss these items. And so thank you, and we will stop recording and sign off now.
Thank you.
Thank you.
Thank you for your participation.
Thank you, Commissioner.
Recorded video will be published on the DFPI's YouTube channel, as well as the DFPI Debt Collection Advisory Committee's public page. If you have any further questions or comments, please submit them to the DFPI DCLA inquiries email.